I'm very excited to have a chance to chat with you all about, some topics that we see come up a lot in our practice, which are termination of employment for a variety of reasons, and also discipline and tangentially performance management as it relates to termination of employment. So in the time that we have here today, we'll spend some time chatting about really some of the key things that employers need to consider when they're considering ending an employment relationship. And we're going to talk about a number of legal entitlements, key considerations, as well as situations where sometimes employers may slip up and create risk for themselves and how to address those. So as mentioned, I'm Alex Pressey. I'm a partner at a labor and employment law firm. So we practice all areas of human rights law. And while we work with employers on all aspects of the employment relationship, often we are contacted when the employment relationship needs to end for whatever reason. So in a year, we probably have hundreds of different termination-related discussions. And so some of the examples that I'm going to use today as we walk through, nothing that I use as an example or a story is going to be a thing of fiction. They're all very much related to actual scenarios. And in terms of what I'd like us to cover today, there are a couple of different areas that we're going to focus on. We'll start with an overview of termination entitlements. And then we're going to try to implement some of those principles to look at what would entitlements be in a couple of different real-world scenarios. We'll talk about discipline, how discipline works, what are some things that employers need to consider. And again, we'll spend some time talking about situations in which employers often slip up and can create liability for the organization. And then we'll talk about some takeaways and best practices. I've included Q&A as a specific item on our agenda, and I will be leaving some time at the end for any questions. But, if questions arise, as was said at the beginning, please feel free to put them in the Q&A. And, to the extent that questions are directly related to the topic that we're covering, I'm also happy to answer questions as we go. Because this is a general webinar, I do just want to be very transparent that I can't answer very specific questions because what I'm able to provide today is general information and guidance, not legal advice. That said, if you have a very specific question, you're welcome to pose it and I'll answer it to the extent that I'm able to in the current setting, or you're always welcome to reach out after the fact. I'm always happy to answer questions that may come up after the webinar offline. So to start off, as I mentioned, it's always helpful to have a little bit of an overview and refresher of termination entitlements, because termination entitlements in Ontario can sometimes be a little bit tricky. And this is partially because employers in Ontario have essentially a dual obligation because employees have a dual entitlement. First of all, employees by default are entitled to what's called common law reasonable notice, or pay in lieu of that notice. And this is calculated based on a number of factors that we tend to refer to as Bartle factors, based on a pretty old case. Now it's from 1960 or so, which sets out the criteria that decision makers are supposed to take into account to assess how long it's going to take somebody to get comparable employment when their employment relationship is terminated. And these include the employee's age, based on the principle that if an employee is older, it's going to be a little bit harder for them to get a job because certainly after a certain point, some employers tend to be less likely to hire an employee because they perceive them as being at the end of their career and approaching retirement. Length of service, because again, the longer that an employee is with a particular employer, the perception is it's going to be harder for them to get a similar role elsewhere. The nature of the job, because different jobs are going to lend themselves to reemployment at different rates. It's easier to find a position, let's say, as an entry-level clerk, for example, versus a senior leader at a company. It's understood that some positions take longer to apply for, and the recruitment processes are by their nature longer. And availability of similar employment. And this is going to relate to issues like, is the employee in a very specialized or technical role such that there are not many other employers that offer a similar job? When we look at common law reasonable notice, there is technically no absolute cap, but exceptional circumstances have to exist in order for the employee to get more than 24 months. So typically, common law reasonable notice is going to range from a couple of months on the low end. It tends to start at 2 or 3, although hypothetically, 1 or a few weeks is also an option. And then it tends to go up to about 2 years, which is what you would get when you have an older senior employee, lots of service with a particular employer. And we can contrast this to the entitlement that a lot of employers tend to be more familiar with, which is the minimum set out in the Employment Standards Act 2000. So if you have an enforceable termination clause in your employment agreement, you can limit the employee's entitlements from that default of common law reasonable notice to their statutory minimums, or to no less than their statutory minimums. I do also want to note that there is room for a middle ground. So if you have an employment agreement with an enforceable termination clause, you can agree to something more than the ESA minimums. You just can't agree to less. And so I've just added here a very quick chart, which sets out the minimum entitlements to termination pay under the Employment Standards Act. And so, as you'll see, roughly employees are entitled to approximately a week per completed year of service, to a maximum of 8 weeks. There's a little bit of wiggle room at the beginning there, but typically it's about a week per year. And this is, again, significantly less than the potentially 24 months that we're looking at from a common law reasonable notice perspective. In addition to termination pay, some employees are going to qualify for severance pay. And so severance pay is sometimes colloquially used to just refer to whatever an employee gets if they're fired. Severance pay in Ontario is a technical entitlement in addition to termination pay, and it's available to employees who've worked for their employer for at least 5 years, and this includes all time spent by the employee in employment with the employer, whether that's continuous or not, whether it's active employment or not. But if they've hit 5 years and their employer either has a payroll of at least $2.5 million, or has had to engage in essentially a mass termination because all or part of their business has permanently closed, then employees are going to get this additional entitlement. Severance pay is an additional week per year of service to a maximum of 26 weeks, and it's prorated for completed months. So for example, if you have an employee who's been with a company for 10.5 years, and that company is a severance employer, if their employment is terminated on a without cause basis, the employee is going to be entitled to their 8 weeks of termination pay, and then 10.5 weeks of severance pay on top for a total of 18.5 weeks. There are situations in which an employee is not going to be entitled to notice of termination or termination pay. And so from the common law reasonable notice perspective, which is the first sort of default entitlement that we talked about, If an employee's employment is terminated on a without cause basis, so essentially the employee's done nothing wrong, but for whatever reason the employer can no longer employ them or chooses not to employ them, they are entitled to common law reasonable notice. If they have engaged in some type of misconduct, which constitutes just cause at law, so it has to be pretty serious misconduct, and we'll talk about that a little bit more later, then they are not entitled to that common law reasonable notice. But they are actually still potentially entitled to these ESA minimums. In order for an employee to not get at least their ESA minimums, they actually have to engage in an even higher threshold of misconduct than just cause, which is usually defined as willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. So in essence, they have to do something intentional and inappropriate, and they have to have some idea that their conduct is inappropriate and will result in some sort of negative consequence. Whatever the negative consequence is also, again, can't be trivial, so it has to be pretty serious, and it can't be something that's condoned by the employer. And this is important because if the employer has a history of excusing certain behaviors over time, it's going to be very difficult for the employer to then switch gears and say, okay, well, this time, we're holding you to this standard. We think it's inappropriate, and this is willful misconduct. One of the things that's really key here as well is that the willful part is very important. So you need that intention. And what this means is that things like being bad at your job, so poor work conduct, or something that is accidental, unintentional, even if it is serious and harmful to the employer, is not going to constitute willful misconduct. It may very well constitute termination for cause, but again, if it doesn't reach willful misconduct, the employee is still going to be entitled to at least that statutory termination pay or notice, if not the actual payment. The general entitlement to notice of termination and termination pay also doesn't apply if the employee has a proper fixed-term employment agreement. And fixed-term employment agreements are something that a lot of employers use, but unfortunately don't use in a way that's going to be entirely effective. The goal of a fixed-term employment agreement tends to be to make it clear that the employee is hired for a specific length of time or a specific task, and to make it clear that at the end of that time frame or task, they don't get any termination notice or pay. So there's no additional entitlements. Essentially, the relationship ends, and that's that. But in order for that to be enforceable, the fixed term has to be less than 12 months. Employment has to actually end at the appropriate time, and there can't be any sort of renewal or extension for beyond 3 months after the term ends. So where we often see issues is employers that have a pattern of hiring people on a 1-year fixed contract. So, you're hired for this fiscal year, and then you're hired again for another fixed term contract, and then you're hired again for another fixed term contract. A court is going to look at that and say, okay, well, the parties are trying to frame this as a fixed term contract, perhaps even the employer and the employee agreed to it. But in essence, if you really look at the true nature of this, instead of the legal fiction of the paperwork, the true nature here is this is an indefinite relationship. And so if you have an indefinite relationship that you're trying to make sound like a fixed term relationship, in essence, what you have is no enforceable termination clause. So in a situation like this, where a fixed term agreement is improperly used, the employee will be entitled to common law reasonable notice. The other reason that fixed term agreements are quite tricky is that if the fixed term agreement isn't very specifically crafted and it doesn't leave the option for early termination of employment, if you fire an employee in the course of their fixed term what you actually owe them is the entire balance of the term. And there have been many cases of situations where an employee will be hired for a year. 2 months in, the employer will decide, well, this isn't actually working out, and will try to terminate the employment relationship and just give them their ESA notice. But a legal decision maker will find that actually the employee is entitled to the balance of their fixed term agreements. So this isn't to say that fixed term agreements don't have their use, but just they should be used with significant caution. And then another example that is often helpful for employers to keep in mind is that there's no termination pay entitlement if an employee has lost their employment because of what's called frustration. So essentially, the contract of employment has become impossible to perform for whatever reason, and this reason is unexpected and unforeseen. So really, due to circumstances totally out of anybody's control, it's impossible for employment to continue. Now, again, what constitutes frustration and what constitutes an unexpected or unforeseen event is going to be a relatively high threshold. It's meant to encompass things like the employer has to shut down their business due to fire or flooding. That makes it impossible for the employer to keep the employee working. It's not going to involve things like bankruptcy of the employer or insolvency. It also doesn't include when frustration is related to disability. So if the employee becomes sick or injured such that they can't perform their job, it may very well be that there's frustration of contract there and employment has to end. But when frustration is the result of disability, the employee is still going to be entitled to their ESA minimum entitlements, which again is a little bit of a tricky nuance sometimes to navigate. So given that, I'm going to walk through a couple of different examples just to compare the difference between common law entitlements that have been awarded by courts and what an employee could have been entitled to if there was actually an enforceable termination clause limiting their entitlements. So I'll go through each example. I'm going to pause a couple of seconds so that you can, consider what you think the entitlement might be, and then I'll provide you with the actual answer. The reason that we're going through this exercise is I just wanted to be very clear that predicting common law reasonable notice can be pretty tricky, and it varies widely. And the notice is both high, but also sometimes unclear. It may not be a very clear progression. There's a little bit of a myth that employees are entitled to about a month per year of service. Sometimes that rule of thumb works, often it just doesn't. And so to give you a little bit of an example, we'll walk through a couple of these scenarios. So in the first scenario, we have an employee who's 63, has 38 and a half years of service, and is a professional engineer. And they design software that's unique to the employer. And so they're on the older side when it comes to barable factors. They have a very significant length of service. They're in a specialized field, and the specific nature of their role is very technical. So I'll pause for a second for everyone to consider what you think the entitlement might be. And so this is a case called Lynch and Abai Canada Corporation. This is from the Ontario Court of Appeal. And in this case, they actually awarded 30 months notice to the employee based on the length of service, specialized role, and lack of comparable employment, particularly because in this case, the employee lived in Belleville, and in Belleville, there wasn't anything like this that he could do. He was still intending to work. He had no intention to retire, despite the fact that that might be the perception. So 30 months notice, essentially the employer had to pay him 2.5 years of employment. Contrast that with, had there been an enforceable termination clause, the employee would have been entitled to 8 weeks notice. And if this employer was a severance employer, another 26 weeks for a total of 34 weeks, which is just under 7.5 months. It's not nothing, but it's much less than 30 months. If we look at example 2, in this case, the employee is 50 years old. They have less than 5 months of service, so they haven't even hit half a year, and they're a senior project manager. So again, I'm just going to pause for a minute. Well, less than a minute. So in this case, this is another Ontario decision. It's Grimaldi and CF&D custom fireplace design. And in this case, the Ontario Superior Court awarded this employee with 5 months and 2 weeks based on what they found to be his owner-like role in this business, and the fact that his employment was so short-term in nature that the court felt it would require him to explain to prospective employers why he was fired so soon after being hired, which might affect how long it was going to take him to find a new job. So he hadn't even been working for 5 months. He got 5.5 months notice. Essentially, the employer had to pay him, again, as long as he'd been working plus a little bit more. Contrast that with an enforceable termination clause, he would have been entitled to 1 week's notice. Example 3. This one, as you'll note, comes from Alberta. And the reason that I included in here is it's an interesting set of circumstances, but while courts there don't have to follow Ontario case law and vice versa, it can still be persuasive if there isn't a case, specifically on point in terms of an employee's age, length of service, nature of their role. So in this case, the employee was 56 years old and had been with the company for 13 years. They were a controller/chartered accountant. And the specific time frame that we were looking at, the termination resulted from an economic downturn in the oil and gas industry in Alberta. And so in this specific case, this is McDonald and Sproul Management GP Limited, the Alberta Court of King's Bench awarded the employee 18 months notice, specifically because of the economic downturn and the lack of availability of similar alternative employment. With an enforceable termination clause, this employee would have been entitled to 8 weeks notice. In Ontario, if this company was a severance employer, there might be an additional 13 weeks severance, again, for a total of 21 weeks, which is more. And the reason that this is different is there's no severance pay in Alberta. Ontario is the only province that has the severance pay specifically. But if you compare it, even if this was in Ontario, even if there was severance pay, we're looking at 21 weeks, so about 5 months, versus the 18 months that were awarded. And then in the final example that we have here, somewhat similar to example number 1, we have an employee who's 65 years old, has 40 years of service, so a little bit older, a little bit longer service, and is a laboratory manager. In this specific case, which was Panchbaya and we'll say Industries Limited, what was key here is that the 40 years of service represented the entirety of the employee's Canadian work experience. And this employee was responsible for quality assurance. He participated in group hiring decisions. He assisted in training of new employees. He reported directly to the assistant general manager. And so in this case, the employee was awarded 26 months notice. So again, a little bit higher than that, typical maximum of 24 months. This was partially because of the length of service, the lack of other work experience. But it was also noted here that the employer declined to provide a letter of reference or to offer outplacement support or services to actually try to help the employee get another job. With an enforceable termination clause, the employee would have been entitled to, again, 34 weeks, so significantly less notice. So when we look at those examples, we're looking at terminations of employment that occur, again, on a without cause basis. So essentially, nobody's really done anything wrong, but for whatever reason, the employment relationship needs to end. So either the employer has decided the employee is not a good fit, the employer needs to restructure operations for whatever reason. All of those are legitimate reasons to end the employment relationship. And also, you're typically going to end an employment relationship on a without cause basis where there isn't sufficiently serious misconduct. So if misconduct is of a low level, infrequent, and you feel that the employee is not, going to be beneficial to your workplace in the long run, chances are that you're not going to reach that threshold of just cause that, again, disentitles the employee to some of their termination entitlements. And so this is where, clear discipline is quite key. Because where we often get reach outs for discussions related to disciplinary terminations, it tends to be related to a single incident that's happened. And unfortunately, propriety and proportionality of a termination decision is rarely going to be assessed by what happened on just that final day, unless the behavior is extremely serious and there was some type of very egregious conduct. Typically, decision makers are going to look at the entirety of the employment history to look at, does the employee have prior warnings? Is there prior discipline on file? Has the employer been consistent in terms of their expectations for employees, the kinds of standards that are in place, and the discipline that's been applied? And what's the specific context here? Are there mitigating or aggravating factors that either, tend to influence towards saying, okay, well, termination wasn't really the only choice here, or tend to make the situation more serious such that really there was no choice but termination of employment. And part of this, where there's low-level misconduct, is going to be a consideration of whether the employee actually was given a meaningful chance to improve the conduct. Really, what we're looking at here is, was termination a proportionate response? Because from a situation where an employer may at some point want to assert that there is just cause, it's key to note that the Supreme Court of Canada, has said that just cause is essentially the capital punishment of employment law. So you really need to have sufficient grounds in order to make that decision. It's not one to be made lightly. And so when we look at progressive discipline, what we're really looking at is a structured process that includes quite a few different steps. And so when I say, a couple of different steps, pardon me, we can look at it from two different perspectives. First, progressive discipline is typically a bit of a ladder. You might start off with some informal coaching or counseling, a verbal warning, escalate to a written warning, maybe a final written warning or a disciplinary suspension, and then a termination decision. Where you can skip steps does include things like very serious misconduct. You don't have to wait for very serious misconduct, for example, that compromises somebody's health and safety to recur. But generally, you're going to be looking at, is the response proportional? Again, consistent? Are there any mitigating factors here? And so when implementing progressive discipline, it's really important to identify the issue clearly. What exactly is it that the employee has done or not done? You're going to want to tell the employee what it is that they need to do. So you have to clearly set the expectation. And you have to give them a reasonable chance to actually improve the conduct. As I said, it's a bit of a ladder, so it makes sense that typically there will be escalating consequences if the issue continues. That doesn't mean that you can't repeat steps or skip steps as warranted, but typically it's not going to be, proceed directly to termination on a for-cause basis, do not pass go, do not collect your termination entitlements. And part of what's really key here is documenting each step in real time. Because again, one of the issues that we see most commonly is an employee who's had performance issues for a long time. Maybe they're a little bit insubordinate here or there, but management hasn't done anything formally about it. Perhaps there's been changes in management. People have just tried to have conversations and be supportive. But then when everything comes to a head, you don't really have past discipline to rely on. While this is most important in a unionized setting where you don't have the option to discharge on a without cause basis, you need to have cause for termination of employment. It's also going to be key in a non-unionized setting where you're looking at, okay, well, can we actually establish that there's significant conduct here such that there could be just cause and the employee isn't entitled to common law reasonable notice at the very least. As I've mentioned, just cause is quite a high threshold. And typically, the employer is going to have to show something more than dissatisfaction with the employee or poor fit. One of the key things that comes up is, well, this employee has been making these really serious mistakes. They're very bad at their job. One of the key things that I would want to leave you with is incompetence, and that's the technical legal term for performance-related issues of that nature, is almost never going to be just cause for termination. Typically, the expectation is that if you're going to take the position that there's cause for termination based on an inability to do the job rather than any sort of specific and potentially egregious misconduct, the expectation is going to be that there's a formal performance management process in place. And that's somewhat akin to the performance discipline process we talked about, but it includes specifically identifying the issues, setting clear, measurable goals, providing the employee with supports to meet those goals, and it takes a significant period of time in order to get to any sort of potential consequence. When we look at discipline, the reason that it's important to make sure that it's clearly documented and consistent is that prior warnings help to show that the employee knew what the expected standard of conduct was, that they knew that there was some type of gap or issue, and that it was clear to them that there would be consequences of not improving. And that might include, wording like any further violations of this policy or any further misconduct of this nature may result in further disciplinary action up to and including termination of employment. And so when you do get to that final culminating incident that leads to the potential decision that the employment relationship needs to end, everything needs to be assessed in light of the full historical record, because otherwise you might be in a position where you just can't support a decision to terminate employment on a for-cause basis. And so when it comes to actually implementing some of these things in practice, there are a couple of different areas where we tend to see repeated issues. I'll start with the ones related to discipline. As I've already mentioned, one of the biggest issues that we encounter is not documenting discipline consistently. And often this occurs for a variety of reasons. Again, there may not be a culture in the company of documenting discipline. There may be a culture more of informal coaching conversations or discussions. Sometimes the question is just capacity. You may have turnover. There may not be consistent supervisory or managerial oversight for that specific employee. And so, it doesn't become an issue that rises to the top of the to-do list, as it were. And sometimes organizational standards change. So there's a little bit of awareness that an employee isn't doing a great job, but nobody is too motivated to do anything about it. And then new leadership comes in and wants to make some changes and finds that their hands are a little bit tied by lack of historical documentation. So one of the key things to do, and again, this doesn't necessarily have to be a particularly onerous thing. It doesn't have to be a situation where, you're creating a culture of fear or anything like that in your organization. Far from it. But there needs to be a little bit of a discussion often in a workplace to reset expectations and make it clear that, certain types of conduct are not going to be acceptable, potentially to provide training on certain policies and procedures and practices, and generally just let people know why you need to hold people to account for certain things. Because if you've allowed certain behavior to go on for some time, as I mentioned earlier, it's very difficult to flip the switch and then legitimately say, okay, well, now we're going to be holding people to account for having engaged in these behaviors that we previously allowed. Another issue is not disciplining consistently. And by this, I mean holding different employees to different standards. We often see this where you have some really strong performers, rock star employees, and they get a little bit more rope, in order to push the boundaries, perhaps behave in ways that others might not, and they tend to be defended by some of their managers because they're considered to be indispensable. That kind of behavior existing in a workplace culture is going to make it hard to hold other employees accountable for similar types of conduct. Similarly, where there is serious misconduct and a termination for cause decision is possible, a big issue is failing to investigate. And, when I say investigation, often this causes people's antenna to raise, and there's concerns because an investigation sounds like a very big, formal, scary process, and it doesn't have to be. The obligation is to ensure that an investigation is conducted as appropriate in the circumstances, and sometimes what that is just a discussion with the employee where you let them know, hey, these concerns have come to light, it's been alleged, or it's come to our attention that you may have done X, Y, Z. We want to meet with you tomorrow, 2 days from now. You give them some time to give you an opportunity to respond. You have the meeting with them, and then you make your decision. But what's important is to have a fair process and give them an opportunity to provide a response, and not just unilaterally decide without ever putting any of the concerns to the employee. Another of the issues that we tend to encounter in our practice is employers unreasonably or improperly asserting cause. So knowing that the behavior doesn't necessarily meet the threshold, but taking the position that there's cause in an effort to not pay the employee what they're actually entitled to, and improperly asserting cause where there's not decent, reasonable grounds to believe that cause might exist actually draws additional potential penalties because it's considered bad behavior on the employer's part, and courts don't like to allow that kind of behavior. So that's something that has to be carefully addressed. This doesn't mean that you will not want to sometimes strategically take the position that something is cause if it's reasonable to do so. So for example, if you've had an investigation, serious harassment has been established, but the employee is a long service employee, there's no history of discipline, there may be some issues with condonation, the fact that at a court of law, it's not 100% certain that cause would be found, doesn't mean that it wouldn't be reasonable to say, okay, well, in our view, this was cause, and as a result, we're not going to be paying you anything if we also think that this rises to the level of willful misconduct. It just means that you can't arbitrarily take that step. There has to be some grounds in order to make that assertion. And again, treating poor performance, and specifically poor performance that hasn't been specifically managed through a performance improvement plan as cause for termination. That is often not going to meet the threshold, and the employee will be left in a position where they can successfully argue that they've been wrongfully dismissed. The employer sometimes is caught off guard because they think, well, I didn't realize that there could be this liability here. From a termination perspective, one of the key issues we see is failing to implement employment agreements. Still to this day, there are a lot of employers in Ontario that don't have employment agreements. They might have a one-page offer letter, particularly where they might have long service employees, people who've been there 10, 15, 20 years, have never gotten an updated employment agreement. And Often, again, employers don't realize that unless they specifically contract into the minimums under the Employment Standards Act, it's the much greater entitlements that apply. Similarly, a big issue that we see is not consistently updating employment agreements. Because updating employment agreements is quite technical. You have to make sure that the termination clause, specifically for the purposes of this conversation, is enforceable. You have to give the employee, if they're an existing employee, something extra in exchange for signing the agreement. So that might be a signing bonus, a raise, an extra day off in the year, a gift card, something like that. So there are specific technical steps that need to be taken. But when the law changes, it's very important for employers to take a look at their employment agreements and make sure that they're still doing what you think they're doing in order to give you that predictability at the end of the employment relationship. I've already mentioned the concerns related to using serial fixed-term agreements in an attempt to avoid termination entitlements. And again, often this isn't malice or unintentional avoidance on the employer's part. It's just a lack of understanding as to what a true fixed-term relationship is. And sometimes a lack of understanding what makes it so. So a lot of organizations that may be dependent on funding, and funding is year to year, so you may very well not have money for that position in the next year and you don't know. The tendency tends to be to have these rolling fixed term agreements, but really the appropriate option would be to have an indefinite agreement with an enforceable termination clause that also makes it clear that in the event that funding ceases, employment is going to end and you're going to be providing the employee with sufficient notice or termination pay in those circumstances. And finally, an issue we see is, employers who are thinking, okay, well, I have all these issues, but I'm going to need to make some changes and restructuring is coming. And then updating employment agreements in order to be able to carry out planned dismissals. This is again going to be considered bad faith or, inappropriate conduct on the employer's part. And so you can't update the employment agreement in order to fire somebody and pay them less. The idea is that where employment agreements need to be updated, they should be done proactively. So where you know that you may have some terminations coming up, the goal is to leave as much daylight as possible between any changes to terms and conditions of employment and then the ultimate termination decisions. And so to address those issues, I've just captured a couple of key takeaways here. The first is to, again, ensure proportionality and consistency and discipline. Make sure that you have a clear process in terms of decision making, what actually needs to be done, what is the kind of conduct that won't be tolerated, and what's an appropriate response. This is going to help make sure that if you do need to take the position that conduct is cause and therefore worthy of dismissal without paying the employee their common law entitlements, or again, if it's willful misconduct without paying them anything with respect to their termination of employment, you're going to be able to defend that decision. And document discipline early, even if it doesn't seem serious, even if it's not an issue that you think is going to necessarily immediately lead to the termination of the employment relationship. Keeping it on record is going to make it easier should you need to do something about it later on. Another key point, and perhaps one of the key ones here, is to implement and update employment agreements and also related policies. The new frontier that we're seeing now is that employee side counsel are often trying to argue that if there's a termination policy that's inconsistent with the employment agreement, that invalidates the termination clause in the employment agreement. That's not currently supportable at law. There's no decision that's been made to allow for that, but the law does change, and over the last decade and a half, employment law has been largely employee friendly. So if you're taking steps to make sure that you have predictability at the end of the employment relationships, it's good to make sure that you're being comprehensive about it and looking at employment agreements and also policies. One of the things that does come up here is sometimes there's frustration from employers because there's been a lot of changes in this area. So in the last 5 years, we've had at least 3 very big shifts when it comes to employment law. And so employers, will feel like, okay, well, am I just constantly playing catch up? I have to keep rolling out new employment agreements all the time. And there is an administrative burden to that. There is also a cost if you're providing, again, signing bonuses or some other type of consideration. But what I would leave you with is, two things. It's not an exercise in futility. We've had a lot of success on behalf of our clients pushing back and saying, well, no, these employment agreements, these updated termination clauses are enforceable and your client has no entitlement. So no, we're not paying you anything and we're not increasing our offer. But also related to that, if you think back to the examples that we walked through, the delta between an employee's potential ESA entitlements and what they could get at common law is so high that I would suggest that even if there is some cost or administrative burden, you would quickly recoup it if you had to deal with any, serious terminations of employment in the coming years. And so it's a good proactive strategy that allows you to significantly limit potential liability. Again, ensuring proper rollout of employment agreements is also quite key, because if you do give existing employees new agreements, you have to make sure that you're very clearly communicating the fact that new terms and conditions are in place and giving them that additional consideration. And finally, keeping apprised of legal developments. A lot of law firms have newsletters, blogs. We certainly do. So I would suggest that you sign up for updates from, whatever firm assists you with your HR legal issues or from a number of them, so that if something happens, and can reach out to your counsel to say, hey, it's been a little bit since we've updated our employment agreements. I saw you wrote about XYZ. Could you take a look? Sometimes, we take a look at employment agreements and we say, well, actually, these are still fine. When we drafted them, we future-proofed them. The new legal development doesn't really impact this at all. You're good, keep using this. And sometimes the answer is, well, actually, some changes need to be made. And so with that, I'm going to take a couple of minutes to answer a few questions.